Well, whatever. Oh, and first I would like to introduce our new city clerk, Clara Van Blorgen.
Glad to be here.
So welcome.
Well, I am
Glad to have you
glad
here.
to be here, thank you.
Will you please call a roll?
Yes, ma'am, I will. Mayor Black,
Here.
Vice Mayor Douthert,
Present.
Commissioner Hodges,
Here.
Commissioner Oakley,
Here.
Commissioner Lister.
Here.
All right, the first person for the interview will be Regina Kardash.
Do not touch it. Okay. That's what I was going to do. Just move it down a little bit.
If you're more comfortable, you can use the handheld mic.
As long as this is picking me up, we should be fine.
Okay, very good. Well, according to what this interview list has, we're going to each take turns reading these questions, and then we will have our own questions, and then the interview will be completed.
Okay.
So, Commissioner Lister, would you like to start?
Number one. I have it, Madam Mayor. Thank you. Hi, Regina.
Hello.
How are you?
Good. Thank you. How are you
Fantastic.
doing?
That wasn't a question.
Next question.
Like, that's an easy one.
Actually, it's pretty close, though. Just tell us a little bit about yourself and your firm and why you're interested in becoming the next city attorney for the city of Madeira Beach, please.
Sure, absolutely. I do know that half the commission is new to me, and two of you have met me before when I was with Trask's firm. I am now with Person and Cohen, and I have with me David Jackson, who is the proposed alternate city attorney, and then one of our partners, Maggie Mooney Portali. So also too, any questions that you may have for them, please feel free to ask. That's why we're all here, to make sure you guys get all the information that you need from us. To give you a bit of background, I have served the entirety of my career working in municipal law. I started out as a legal intern with the city of St. Petersburg when I was in law school. From there, I worked with the law offices of James W. Denhart for 4 years, representing Pinellas Park and Reddington Shores, in addition to a whole host of private law practice, ranging from family law to probate and some other areas. I did have my own firm for 2 years, where I primarily did private representation. I also did some work in land use and zoning. And then from there, I went to Trask's firm, and now I am currently with Person and Cohen. Person and Cohen is a wonderful fit for me because we solely focus on local government law. 3 of the attorneys in this firm are board certified in city, county, and local government law. We serve clients as special districts, we serve municipalities, we serve fire control districts, community development districts, all of which have a common element and a common theme with sunshine law, public records compliance, and those types of issues. And having that experience really has helped move my career forward to help me become board certified. That was part of the reason why I made the move from Trask's firm, is they were trying to push me more towards the private client representation, because I was one of the only attorneys in the firm at the time that had my own book, my own private book of business. And I did leave that with that firm when I came to join Person and Cohen.
You just answered like 7 questions.
Oh, wow, good, okay.
I'm just teasing. Regina, it's nice to see you again.
You too.
What do you believe are the most important issues facing a city attorney?
Well, those can vary from city to city, and I think with this particular city, you have seen a host of changes in a very short period of time. So I think that bringing stability and clarity to what you're doing would probably be one of the most important things to assist you with. I know just from reading what I've read in the paper, I know that you're facing a potential recall. I know that land use and development is a hot topic issue with everybody that you serve in this community. But that kind of rolls into my theory and the way that I was taught to practice local government law. My job is not to practice politics. My job is to advise you what the law is. I'm not here to push an agenda of pro-development or anti-development. That's not what the job of a city attorney is. The job of the city attorney is to advise you as to what the law is, to help you make the choices that you believe are important for your constituents and for your citizens.
Responsive, thorough legal advice is an important aspect of a good city attorney, of good city attorney services. Specifically, the availability to communicate and respond to issues via phone, email, and occasionally in person will be expected in a timely manner. Tell us how you plan on being responsive and thorough in meeting with the legal needs of our community.
I've had some practice in making sure that I'm available because all clients always want to have their attorney available when they need their attorney available. So that's something that is common no matter what kind of law you practice. One thing that I have done with my public clients that I did not do with my private clients is make sure that you have my cell phone number. That I think can be very important, so that you know that I am there for you when you need me to be there. That being the case, I also know that sometimes I am going to have court hearings. I am going to have other meetings. I do represent other clients. In that case, you have a firm of 6 other attorneys that also will make sure that they are available for you. If you can't reach one of us, somebody else will be there if you need an immediate answer to your question. Typically, I find that emails work better because you don't always know where I'm going to be and when I'm going to be there. So sending me an email, not only that, it gives, a record of, hey, I sent this to you, and then I can respond and you have a record that I gave you a response. And I think that can be very important too, in terms of, going back and saying, okay, so what did you advise me on this particular issue? Or I can't remember exactly what you said, and then you have it there and you have it in writing for you. And it's easily accessible.
Thank you.
We're just going right down this list. Okay. Given the cost of the senior attorney services versus your paralegals and associates, how will you balance controlling costs for the city with quality legal advice?
So we don't have the same structure that I think you're used to. One of the things that I'm doing differently and that I put in the proposal is that I have a retainer. And the retainer that I proposed was $8,000, and I did that based on an estimated 40 hours per month of time. And what I actually specifically did was look at the services that you're requesting in your RFQ. The minimum 4 hours per week to staffing at City Hall. That right there is going to be 16 hours a month. In addition to that, the regular council meetings, the other boards of the city, advising the different departments. So the retainer is really designed to include your legal services. We do think that on the front end of this, we're probably going to end up eating a lot of that time. And it's probably going to end up being a lot more than 40 hours a month, just in the initial probably 6 months to a year. It's going to definitely work in the advantage of the city in terms of representation on your routine legal needs that are going to come up every month. The things that would be outside the retainer would specifically be litigation, and there's a couple reasons for that. One, litigation is incredibly time intensive. That 40 hours a month, is not going to include your litigation hours, and I know that currently you do have substantial litigation needs. So that wouldn't be included in the retainer. Also, too, with a transition from one city attorney to another city attorney, there's going to be an examination of the files to make sure things that are close to settling, things that are close to ending, it may not make sense to have a new attorney come on, relearn the file, and then work through that. If you have matters that are close to settling and close to the end, it may make more sense, and this has to be determined on a case-by-case basis after looking at what legal issues are pending, to let the attorney that's currently handling it finish that file until it's done to a certain point, maybe until the appeal is done on it or something like that. Also, too, there may be matters that we would prefer you refer to special counsel or a counsel that may have more more litigation-heavy caseloads. We look at when litigation matters arise, we look at the complexity of the matter, we look at the estimated hours it's going to take, and we look at the specialized litigation needs for that particular issue, and we want to make sure that you have the best legal representation, even if that's not with us. One of the areas that we routinely would refer things out on would be employment law. We're not employment law attorneys. You can get a specialized certification in employment law. Our attorneys don't have that. We're specialized in city, county, and local government law. So depending on what the litigation issues are, we would examine those and then advise you on how we think you should proceed. But at the end of the day, it would be up to you on whether you wanted us to retain the file, you wanted the old attorney to retain the file, or you wanted us to refer it out to somebody to handle it as a specialized legal matter. Hello.
How do you keep the city informed of new laws and court decisions that are, that come up?
At our firm, we consider that to be of paramount importance because of the area of law that we practice in. Every legislative session is almost like a marathon in terms of keeping track of legislation, keeping track of what's coming up, what's getting looked at favorably, what the Florida League of Cities is working on to make sure that, and that's just legislation, that's not even in the realm of case law. But our attorneys, we regularly lecture on changes in the law, so we take the time to research this to make sure that we're up to date and abreast of everything that's going on, and we communicate with each other so that if one of us is working on one particular aspect or following a particular piece of legislation, we can communicate that to the other attorneys in the firm so we're all aware of it and aware of what the status of it is. Also in addition to that, we all attend CLEs. I am a member of the Florida Municipal Attorneys Association, and I have been since 2008. That's an annual conference that is put on statewide where attorneys that practice the municipal law from all over the state attend. In addition to that, I am currently the vice chair, and next year I will be the chair of the St. Petersburg Bar, their local government law section. So I am actually helping to design the CLEs that are going to be taught to other local government law attorneys in the area. We just did one recently on technology in the law. Attorneys now are required, no matter what area of practice you're in, you're required to have technology CLEs that are within every 3-year cycle. And so we put on one that was specific to technology and public records, and the speaker for that was Janine Williams, who's currently the chair of the St. Pete Bar local government section, and the chief assistant city attorney for the city of St. Petersburg. And she gave a presentation on things like Facebook and blogs and how that works with public records and what the responsibilities are of city officials who do talk about public business on those types of forums, what record-keeping tools there are, and things like that. So we work very hard to make sure that we are on top of the legal issues and current status of the law that's going to affect you and all of our clients, really.
The sixth question is mine. Tell us about a conflict that you've experienced with either an elected official or a coworker where they didn't agree with your legal advice, and how would you negotiate or navigate that situation? I'm sure everybody agrees.
Yeah. It's actually quite common, I think, for people to push back against the attorney if they don't like the advice that they're receiving. That's a very common situation, whether you're in public law or whether you're in private law, and I have experienced it on multiple times. And quite honestly, it will depend on what the issue is. Sometimes the law is clear, and I know what I'm talking about, and I'm going to stand firm on that. If it's something where it's questionable, I will re-examine the legal issue to make sure. Even if I think I'm right, I like to re-examine and double-check and say, okay, you don't agree with this. Why don't you agree with it? And here's what I am basing my opinion on, whether it's a statute, whether it's an attorney general's opinion, whether it's my experience in litigation in the legal field here in Pinellas County, which I have spent a significant amount of my career litigating in Pinellas County. So I am familiar with, the different judges and with different points of view on how they handle their cases and their caseload. So that's, one aspect of that. Sometimes, if it's a policy issue, that's not necessarily for me to say. That's why you're the elected officials. That's why, your citizens and your constituents put you up here sometimes, is to make those policy decisions. My job is, like I said, it's not to advance an agenda. My job is to give you the law and what the law says, and I'm going to do that. Now, there are situations, one of my favorite, most recent examples is what the city of St. Petersburg just did with their campaign finance law. They made a decision that was specifically against a very recent Supreme Court case regarding corporate dollars that go to finance political campaigns. And they made a decision, a policy decision, that specifically is against that Florida Supreme Court case. Their attorney sat there in an open meeting and told them, if you do this, you are going to get sued and you are going to lose. And that commission decided that they were going to make that decision anyway because they believed it was the will of their citizens to act in that manner. You're welcome.
Regina, I have a question here. In a job-related skill, what is your strength?
I think that one of my biggest strengths is probably researching. It's something that I enjoy doing. If that was the only thing I did in my job, I think that would probably be the best part of it. I would be very happy, but, being an attorney, there's a lot of different aspects of this that go into it. So I think definitely, the research, going out there, finding what the answer is. I wish that there was always clear-cut answers, but that's not the world we live in, and that's not, the practice of law.
Excuse me. In municipal law, reducing risk is often in conflict with the action or moving an issue forward. Tell us about a project where you provide legal counsel that successfully balanced these competing factors.
And the competing factors were?
Conflict with an action, moving an issue forward.
To move an issue forward when, okay. Trying to think of I can't really think of a solid example of that because there wasn't really conflict about it. But I guess currently in both of the other communities that I represent, we're doing extensive comprehensive plan. Our evaluation and appraisal reports, we're due, and we're sort of in the middle of that particular process. And, I think that it can be a very difficult area of municipal law to understand. Land use and zoning is complex, and there's a lot of competing interests in this state, both private and public. So making sure that the individuals who are making those decisions have a good handle on what the law requires. These are the elements that have to be in your comprehensive plan. These are how they affect, your zoning code. These are how, your zoning codes are implemented, and this is how this works. I think making sure that education is in place first goes a long way in resolving conflicts later on, because then everybody's on the same page of, okay, this is what we have to do, and this is what we have to accomplish, and then these are the areas where we have choices.
You're currently working in Indian Rocks as well?
No, Indian Shores.
Indian Shores?
Yes.
Is there any other cities that you're working with?
Yes, I am the city attorney for Indian Shores, the city attorney for Bel Air Shore. Indian Shores, just to give you a comparison, they have a population of 1,500. Bel Air Shore has a population of about 100. And I also serve as the board attorney for the Pinellas County Homeless Leadership Board, which is the continuum of care to serve the homeless community here in Pinellas County. And I work with them both on their federal requirements and on their sunshine law, because they are a board that's subject to sunshine and public records. So I work with them on that. I also serve as the board attorney for the City of Palmetto Code Enforcement Board. I think that's it at the moment. And I am an appointed public official. I'm appointed by Commissioner Justice, and I serve as the chairwoman for the Pinellas County Local Planning Agency, which makes the decisions on and recommendations to the county commission on the comprehensive plan changes and amendments and occasionally some zoning issues as well.
Do any of your meeting dates with those other cities, are they conflicting with ours?
That's interesting because I believe you all meet on Tuesdays, correct?
Right.
Actually, every single client of mine except for the Pinellas County Homeless Leadership Board meets on Tuesdays. Which I think, there's a lot of different ways. If you wanted me to be your city attorney, both myself and my firm would be more than willing to work out whatever we can to make that happen. Not only because the vast majority of these meetings are already on a Tuesday, but also because they're currently existing clients. I'm not going to be asking them to move their meetings. I'd have to go to basically 3 public entities and tell them, I can't meet with you on Tuesdays anymore. And there's a lot of different solutions that we can come up with for that, but that, all depends on whether or not you want me to serve the city.
Excuse me. What do you believe are the most important attributes to be a successful negotiation? Give us an example of an issue project that you have successfully negotiated.
For successful negotiations, I think being very familiar with the subject matter, whether it's a development negotiation, whether it's a business negotiation, and sort of what all the parts are at play with that, and also what laws are going to apply to that, because that's definitely going to affect your negotiation strategy, knowing what you can and cannot do, and ultimately what the end game and the end goal is. So taking into consideration all those different factors and then working through, okay, well, what is it that the other side wants, the other person or entity, what are their end goals? What is their end game? What is it that they're trying to accomplish? And then looking at those two halves to make this something that's more cohesive, that both sides are happy with.
Thank you.
The most difficult negotiations, by the way, practicing in family law, no matter what you work out, nobody is ever happy.
It's usually a sign of a good negotiation, isn't it? When
Yeah, right?
Either side are happy.
Everybody's giving up a little something.
Do we have to do both questions to both candidates? I mean, the same questions to both candidates?
I don't know legally if we do or not.
I'll stay on
Maybe you
task.
can tell us.
I'll stay on task. Tell us, I think she's already answered it. Tell us how you would alleviate our concern that we would be lost in such a large firm working with a town our size.
Well, I think that we kind of pride ourselves in making sure that our communities receive the attention that they need and the services that they need. I think any attorney worth their salt is going to make sure that their clients are happy in terms of the attention that they're getting from their attorney. I think that kind of begs the question and feeds into people switching attorneys is when you're not getting the individualized attention or quality of representation that you want. A lot of that too kind of feeds into what I think really is my theory of the attorney-client relationship, and that's definitely based on trust. You have to trust the information that I'm giving you. I have to trust that you are going to understand it and follow through how you think is appropriate for your city and for your constituents, and also keeping in mind too that my client ultimately is the city. The individual commissioners, the individual department heads are not my client. My client is the city. And at any time, if the individual interests of commissioners and the city diverges, then that's a discussion that we need to have about why that's happening and what that looks like in terms of your legal representation. I am very intent on making sure that Chapter 112 ethical considerations are followed. Also, I am very active in the Florida Bar, and I like to make sure that I'm following the Florida Bar mandates in terms of my responsibilities to my clients and my responsibilities in terms of what my client representation is for you.
Regina, have you ever had to defend a city in a lawsuit? And if so, what was your success rate?
Actually, I think I know of 2 lawsuits that I did when I was at Trask's firm that I represented Madeira Beach specifically on. One was a bid protest issue, which ended up settling favorably for the city. And then there was 1 or 2 foreclosure actions where I was preserving the city's code liens. I'm not sure how familiar you are with how code liens work. But when you have code liens on a property and then the property goes into foreclosure, if you do nothing, then the code liens are wiped away. But if you step up and you defend those, you can preserve those and in some instances get them back. There was a time when we were arguing that they had superiority, lien superiority over mortgages and other types as almost like a tax lien would. But with the City of Palm Bay case, that has shifted and changed, and they're no longer entitled to that type of priority lien status that we were arguing for prior to the Palm Bay case.
Land use issues have been and are expected to continue to be a contentious part of city business. Please tell us your experience in handling land use board appeals and other land issues.
Okay. I do have quite a bit of experience specifically with land use law. Just my position as chairwoman of the LPA, that in and of itself has given me a phenomenal working knowledge of what goes into all of this. I did advise the Madeira Beach Planning and Zoning Board for quite some time. Then I also advised the City of Dunedin on occasion. I advised the City of Dunedin local planning agency. And as I mentioned, I'm currently going through extensive comprehensive plan rewrites and EAR amendments to make sure that both of my communities are in compliance with the current statutory items that have changed since the last time they did their comp plan rewrites. And I don't know when the last time the City of Madeira Beach had to do that, but that is an extensive process. And in tandem with that, I've also been working with FEMA on the floodplain management ordinances for those 2 communities, which I think is definitely an important part of current city planning, particularly with this being a coastal community. I know that we just went through Hurricane Irma and had to deal with a lot of issues that came up with that, and making sure that you have strong building codes that meet what the current standards are, and that your comprehensive plan reflects that and reflects a strategy of the city to deal with those types of issues, in the event that we do ever have major flooding, and in the event that, that there is a catastrophe here. We want to make sure that our buildings and everything that we're allowing to be put here can withstand those types of events and major occurrences.
The City of Madeira Beach operates on a very tight budget. Due to this reason, is there any room for negotiation on your billing rates?
We consider our billing rates standard in terms and pretty much market in terms of what we have set forth. That being the case, it depends on what you wanted to include in that retainer. Like I said, I gave you the basis of what I did in terms of coming up with that retainer rate. I think that at this point in time, it would be more beneficial for the city to have a retainer rather than going on a straight hourly basis, and until things sort of settle down for you all and there's not quite so much going on.
As you know, and home rule is in every place you look anymore.
Yes.
And people are fighting it left and right and up and down. And I just would like to hear your side of what you feel home rule, how it would affect the city, positively or negatively.
Well, the amount of legislation that has been circling around home rule is quite frankly rather disturbing. In the almost 10 years that I've been doing this, I've never seen such a vehement attack on home rule as I have in this particular legislative session. Now, that being said, I know at other times During the course of the history of the state, there have been similar attacks to home rule. I like to follow pretty much what the Florida League of Cities is putting out in terms of, different pieces of legislation that they're supporting, and because they are very adamant in defending home rule. And then additionally, too, we also have this particular go-around, the Constitutional Revision Commission. I currently am I work a lot with the Florida Association of Women Lawyers, and I am currently the chair of their Constitutional Revision Commission committee. And in that respect, I am actually helping to lead and monitor the different aspects of the CRC and things that are coming forward, which are going to be some potentially significant revisions to our state constitution. And I'm not sure how familiar this commission is with that process and what's going on and where we are on that. One of my committee members is P.K. Jameson, who happens to be the chief counsel to the Florida Supreme Court administration, and she actually has been helping me to sort through the different pieces of proposals that are coming forward and what those look like, and the impacts that may have on my clients. Actually, on that particular committee, there are 4 other attorneys that practice local government law and are certified in local government law, all because we're interested in what these proposals are and what they're going to look like. Now, on behalf of Fall, what I'm doing is vetting those to bring them to our big board to see whether or not there are things that fit within the Fall mission that they may want to support and educate the public about.
So but do you see it affecting, how do you see it affecting us, negatively, positively? I mean,
The more that the legislature and the Constitution chips away at home,
takes away from us?
It's going to take away from cities and counties, and I really think that it's important to be active in terms of making sure that our legislators know what our desires are. Now, that being the case, I always, like I said, it's not my job to institute the policies of the city or to advise on political issues. When it is the will of the commission, I always ask, and I've done this in Indian Shores, that, saying if there's this particular piece of legislation that you want to let your legislators know that you're in support of or you're in favor of, pass it as a resolution. Give it to them as a resolution in writing so that they know this is where you stand on this issue and that this is important to you. I do believe that the Council of Mayors just recently passed a resolution
Yes.
to that effect. And it
We
didn't-
did as well.
Yes, and it wasn't to a specific piece of legislation, but in terms of defending home rule just unilaterally and any type of legislation that's going to sort of chip away at home rule.
Thank you.
You're welcome.
I've got some more questions. If you have more questions, we can continue round robin.
Go ahead.
First of all, what do you know about Madeira Beach?
I know that you're in the paper quite a bit lately.
Really?
I have lived in Pinellas County since I was in law school. I was born and raised over in Hillsborough. So my experience with Madeira Beach growing up and sort of in my personal history has just been coming to the beach and that type of an experience, versus the experience of a resident who's here all the time, may not always necessarily like all the tourists and visitors, and that can go both ways. But I know that you're a thriving city. I know that you have a healthy commercial district that provides a good tax base. I also know that you have quite a large, I think around 4,500 is your current population of citizens, which is a little bit larger than some of the other communities here up and down the beach. And that sort of puts you in a leadership role in terms of the decisions that you're making and what that looks like in terms of the community as a whole up and down the beach. I do know also that you have a wonderful community center here. I was actually here when you did the dedication and the opening. I took the tour and saw, the band shell out there and the fitness room and all the facilities that you have built here and you have put here. I think that is a testament to what you're willing to provide and the quality of life that you're willing to provide to your citizens here.
All right, thank you. Why did you decide to be an attorney?
Looking back at my Stetson application, I actually believe that I said I wanted to help people, and I wanted to give the greatest benefit to society that I could. You know, whether that was a judgeship or whatever that looked like. I actually was not familiar at all with local government law when I started law school. I didn't have it in my head that this is the type of law I want to practice and this is what I want to do. You know, so that really wasn't part of the equation when I started doing this. And I actually didn't want to be an attorney. I wanted to be a professor. My undergrad degree is in art history and theology. And I wanted to get a PhD in art history and teach. But that was another 8 years of school, and law school was 3, and my dad was like, here, I don't want to pay for 8 more years of school, but I'll pay for 3. So I was like, okay. And everything just kind of flowed from there, and it kind of flowed organically and naturally, and this is where I ended up, and I am quite happy, and I really enjoy doing this type of law.
What kinds of things motivate you?
Well, I actually recently started a family, so my main motivation right now is my 4-month-old son. Right now, he's kind of the little dictator in the house and is telling me everything I need to do and when I need to do it.
That's the way they do it.
Yeah.
What would you say is your greatest achievement outside of your profession? I know what it is.
Well, yeah.
New baby.
Yeah, I mean, that's a big one. That definitely is a big one. That was a game changer for me, you know, quite frankly. I think it is for anybody that's ever had children, you know, that changes your perspective and your outlook. Aside from that, actually, I very early on in my career, when I still had free time, I got a teaching certificate in yoga, and I am a 200-hour certified prana flow instructor, and I've taken yoga classes all over the world. I've actually been in a DVD series that is it's yoga and the artist's journey, and it's about creativity in life and in your practice and what that looks like, and I think that was pretty substantial outside of the law. Took up quite a bit of my time.
Can you tell me what the biggest mistake you've made and what you learned from that mistake?
You know, we all make mistakes in life. I'm trying, you know, you're talking about the biggest mistake. I'm not, not quite sure. So, I think actually one of my bigger mistakes have been some of the choices and some of the people I've dated throughout my life. So, but you know, that's all kind of settled now, and what I learned, I think, is that I have more strength than I sometimes admit to, and then also that not to sell myself short.
How would your friends describe you, and what 5 words would you use to describe yourself?
Well, I think intelligent usually is one of the top ones that my friends would use to describe me, and probably giving. You know, the process of growing up and learning to say no when you always want to say yes and be helpful, you know, can kind of shift, you know, when you have to reorganize your priorities in life, and you have to learn how to say that no. So, you know, I think that, you know, intelligence, and then under that the giving, but then with that caveat of knowing when to say no. Personally, I think that I'm a hard worker. I try to do things right all the time and make sure that I'm doing the right things. Sometimes that looks different to different people. And at the end of the day, I think gratitude is very important. And I always try and be grateful for what I have, and, you know, going back to the mistakes, being grateful for the lessons that those mistakes teach me, and gratitude in life, above all else, will serve you well.
What challenges are you looking for in this city position?
I think that one of the biggest challenges is going to be how to close out the transition that this city is currently in, and what future transitions might look like. I do know that, you know, just because the 5 of you are appointing, you know, a city attorney now, that, you know, a year from now, 2 years from now, 5 years from now, that might be different. And I think that that's going to be a big challenge in this position, is what these transitions look like for your city. You know, I do think that this is a risk, quite frankly, because you have had turnover. You know, just looking at the past 10 years of the history of the city, this isn't something that's new to this community. This is something that has sort of reoccurred. And making sure that these happen in a way that protects the interests of the city, that protects the interests of the citizens and the taxpayers who rely on the 5 people that they put up here to make decisions.
Thank you. And my last question is, why should we hire you as the city attorney?
I have a familiarity with this city, with the beach communities, and with Pinellas County as a whole. And I think that familiarity is going to serve you very well. Not only that, I have been, over the past several years too, becoming more and more familiar with Tallahassee and what that landscape looks like. And I think that's something too that can serve the city here in the future. And it would be my goal to use all these aspects and these skills that I've been developing throughout the course of my career to serve your city. And also, I am a believer in lifelong learning. And I think that is going to go a long way in making sure, you know, whether I'm here at Madeira Beach, you know, or elsewhere throughout this county or throughout this state, that knowledge of lifelong learning. You know, nobody's ever going to know everything. But it's what you know and what you have in that particular moment that's going to help, you know, your clients and the people who rely on you.
Thank you very much. Commissioner Oakley?
I don't know if you wanted to hear or had any additional questions for Maggie or for David with respect to the proposal or any of their aspects or points of view for some of these questions. That's up to you. But they are here if you would like to ask them some questions as well.
I had a question.
Yes.
What policies and procedures have you developed or helped develop to guide planning boards and board of commissioners to ensure that all ordinances are faithfully followed?
So one of the most important things that I always return to is education, and making sure that the people that are making the decisions have a solid education and knowledge base about the decisions that they're making and what they're doing. And that can look different in different communities. Also, too, making sure that everybody's familiar with, you know, what a quasi-judicial hearing is, you know, what the elements are in a particular code, you know, making sure that the packets that are provided, you know, regarding whatever it may be, you know, clearly outlines that. And I've seen that vary from community. I mean, I know what I get from the county. We have a meeting on Thursday, so, you know, I know what to expect in that packet. They go through specifically, you know, what the comprehensive plan elements are that they're dealing with. They go through specifically what the elements of each decision are. You know, that aspect of it, I think, is really going to be what's most important. And then making that routine and making it part of what the principal practice is in terms of that education. And also, too, knowing what information you need from your building official, what information you need, from your, the city planners and people who are going to have the professional expertise to answer the questions that might arise as part of that particular hearing.
Okay. Back to something you said earlier, on availability.
Yes.
That right now your Tuesdays, your second Tuesdays are tied up.
Right.
Okay. Just wanted to make sure I heard that correctly. Okay.
To that end, the fact that I am having a deputy city attorney, Mr. David Jackson, is very adept at advising councils and commissions. He would be available in my absence to the extent you wanted to keep, your Tuesday meetings. I understand that that is a significant disadvantage to not have your city attorney available when you have your meetings. It wasn't part of your proposal that you put out. Sometimes you'll see it where it does specify, don't apply unless you're going to be available, on this, at this date and time. I've seen that in proposals for city attorney positions. That being the case, I do want to point out that at this point in time, this would be my client load for the foreseeable future. If you all chose to hire me, between you and Indian Shores and my other clients, I certainly feel like at that point I'm sort of at capacity for a while. Especially until I can gauge, what your needs are going to be and whether or not that estimated 40 hours per month is realistic for what you're going through and some of the issues that you might be facing in the future.
What days do you meet with Indian Shores and Bel Air Shores?
They're both on Tuesdays.
Second Tuesday?
The second Tuesday is Indian Shores. Bel Air Shores the third Tuesday. And then the city of Palmetto is the last Tuesday, which is usually the fourth Tuesday. Currently, I have the first Tuesday of the month available, and pretty much any other day of the week except for Tuesday would probably work out better. One thing to keep in mind is that there are always going to be scheduling issues that come up. Whether, you're having a special meeting or Indian Shores is having a special magistrate hearing or what it is, whatever, the case may be. But to that end, we do also have 6 attorneys, that we can have cover different things. However, I know that it's important that you want your city attorney, the person who is your attorney, to be there. And I always make every effort to be there for my clients. And quite honestly, I don't think it was until I went on maternity leave that anybody really covered anything for any of my other clients, right? Yeah, so I make an effort to plan well enough in advance. And to that end, sometimes it's a first come, first served basis. I do know too, particularly during budget season, because I used to cover the meetings for Tom when you all were passing your budget, because nobody could do them on Tuesdays in this county because the school board wants to have their Tuesday budget hearings. So there's always going to be a little bit of a shuffle, for things like that might come up where, we need to accommodate schedules, but we're not going to leave you without coverage. Oh, Maggie asked that I remind you too, if you did switch your meeting days, that we would pay for any costs that were incurred to the city in advertising that and making sure that that was appropriately noticed. That would fall on us, and we would incur that bill on behalf of the city to make sure that public notice went out.
Thank you.
Okay.
Actually, it'd be a charter change. Mm-hmm. We'd have to get a referendum for it. The charter that way.
Actually, your meetings, your charter currently provides that your meetings are set per resolution that you pass. It's part of your procedures, and I believe it's in a resolution that you pass immediately after you take office. So once the new commission is elected, you set your rules of procedure and per a resolution. Part of that resolution is what your meeting dates would be.
Okay, thank you.
Oh, excuse me. I have one more question. I'm sorry. I don't know if anyone else does. When you mentioned quasi-judicial.
Yes.
Is it necessary to have a quasi-judicial hearing for all cases involving developments and land issues, or can it be done through a legislative hearing?
That's a fundamental difference in what you're doing. So things that are quasi-judicial, you're taking something that's already established legislatively, and you're applying that to the facts and evidence that you're receiving within the quasi-judicial hearing. So there's a distinct difference. So not all land development is just carte blanche quasi-judicial. You know, if you're legislating and you're saying this is the policy and this is what we're establishing, that's legislative. But if you're taking a piece of legislation that's already in place and you have those set principles and that set criteria, and you're applying the facts and evidence that you receive in that hearing to what you've already legislated, that's what's quasi-judicial.
Thank you.
You're welcome.
Thank you very much. Anybody else have any other questions? Thanks again. All right, I guess, Mr. Brooks, you're next.
Why don't we take 5 minutes?
Oh, you want to take?
Take
All right,
5
we're going to
minutes.
take a 5-minute break then.
2:52.
Two PM? 2, fine. No, 1:58. Stop it.
Oh, that's,
Yeah.
We'll get somebody to fix that clock.
And I apologize, Mr. Brooks, but a member of the audience has asked to ask some questions of the attorneys. So can we finish up with Regina first?
Oh, yes, no problem.
Thank you. Mr. Hendricks?
John Hendricks, 569 Normandy Road, Madeira Beach. My question is, if there are 2 or more commissioners speaking with you in private together, is that or is that not a violation of sunshine laws? Yes or no?
So if they're talking to me about something that's going to come before the commission,
Yes.
absolutely,
Thank you.
absolutely.
If 2 commissioners or more are at another place with a resident, a citizen, together, talking about city business, is that or is that not a violation of the Sunshine Law? Yes or no?
On those facts alone, I would say yes.
Thank you.
One thing that, you know, I certainly understand, your questions and kind of where you're going. My answers are certainly specific to, the facts, the very sparse facts that you provided. I also always advise my clients about the mere appearance of impropriety. So I always advise against having those types of discussions, whether or not it's something that would be subject to sunshine law. One-on-one interactions with citizens are one thing, but when you get more than one commissioner, it doesn't necessarily look good. So I appreciate where you're coming from with that question.
Okay, so if several commissioners came up to you at the diocese before the meeting.
Mr. Hendricks, could you talk into the microphone? I can't hear a word you're
Okay,
saying.
sorry.
Thank you.
if several commissioners came up to you at the diocese together before the meeting to discuss the meeting, that would be a violation of sunshine law.
I would talk to commissioners one-on-one,
Thank you.
but addressing questions like that, there's sunshine law, I have to abide by it. I would always advise commissioners, mayors to abide by the sunshine law, yes.
Thank you very much.
May I interrupt? Are you speaking of, would it be a violation of sunshine law if two commissioners are talking to you as the attorney about the agenda and where items belong on the agenda?
These are very fact-specific questions. So at the end of the day, you have to look at what is being asked and what the topic of the discussion is to ensure that that's something that falls under sunshine. Something administrative is a little bit different, but you also don't want to have, again, that mere appearance of impropriety. So I always gear towards that. I just advise, until that meeting starts, do it in the meeting.
Thank you.
Does anyone else have any questions? All right, thank you very much. All right, Mr. Brooks.
Good afternoon.
Good afternoon.
It's nice to be here. I would like to kind of go through a little bit about my background. Perhaps I could do that first before the questions. If not, I could do that after the questions.
Go ahead.
Okay. Well, to introduce myself, I haven't met any of you in person yet, I don't believe. My name is Ralph Brooks, and I'm board certified in city, county, and local government law, and I've been board certified in this field since 2004. What board certified means is you have to have an apprentice period of 5 years, and you have to take a test, a written test, and you have to get recommendations and review by a panel of peers that are already board certified in the Florida Bar. And they test you in all aspects of city, county, and local government law, finance, land use, zoning, employment. So you have a good basic understanding of almost all the areas that come before you. I've served as litigation counsel for Monroe County for nearly 10 years. Monroe County is the Florida Keys. I started when Monroe County did not have the municipalities of Marathon and Islamorada. But I helped Marathon and Islamorada and their attorneys get started with the transition to be city attorney. I also served as assistant county attorney for Sarasota County, and I was in charge of all land use, natural resources, the garbage, waste hauling, recycling, pollution control, trust funds, code enforcement. I've served as the city attorney of your neighboring Pinellas County city, St. Pete Beach, which also has faced similar controversial land use zoning decisions in the past 15 years. I've also served as city attorney for the city of Bradenton Beach, which is a very similar barrier island city. St. Pete Beach had a population, or has a population of about 11,000. Bradenton Beach has a population of about 1,500. Bradenton Beach is interesting in that it's on a barrier island called Anna Maria Island, and there are 3 cities there, Anna Maria, Holmes Beach, and Bradenton Beach, just like you are, in a way, on a barrier island that you share with adjoining municipalities. Many of the same issues that I faced in the Keys, in Key West, and in Marathon, Almirada, Matecumbe Key, those are issues that I face in Bradenton Beach and other barrier islands. I also served as town attorney for the town of Yankeetown, and that's a very small town of 700 people. I was kind of talked into a visit up there. Once I visited, I kind of fell in love with it. It looks like it's from the pages of National Geographic magazine with cypress trees and Spanish moss. It's between Steinhatchee and Crystal River, if you can't imagine 2 more bucolic, idyllic places in that part of Florida. Although the town of Yankeetown is only 700 people, they're very civically engaged, and they're quite active. They are a community that's worked closely with the Department of Economic Opportunity. We were able to apply for a grant and work with the University of Florida and DEO to help prepare coastal resiliency plans, which includes a science plan and a business plan, and received money that was well spent there. City of Bradenton Beach, I worked with DEO and University of Florida as a Waterfronts Florida community. There's still a Waterfronts Florida community. And right now I work with the Conservation Clinic pro bono with them on setting up anchorages and mooring fields, working with Fort Myers Beach, other working waterfronts communities, and guest lecture at the meetings that they have, and assist their communities kind of on an as-needed, just free basis. I'm in love with Madeira Beach. I just love your setup here. I can think of no better place to spend time working, and certainly our life should be work, should be family, and should be in a hobby. And certainly I feel like this would be a wonderful place to work. I enjoy working with Barrier Island cities. I am interested and captivated by the issues that they face. Living in the island of Key West for 8 years, I saw all of the interrelationships between tourism-based economy, families on vacation, spring breakers, people who buy condos to live in, people who buy condos to vacation rent, all of these different competing interests, and looking for the balance to ensure that the quality of life and the reason why all those groups came here, is preserved. So there's quite a lot of opportunities here to work in. I noticed that there is litigation right now. I've reviewed the past 3 months of your bills. I can tell you that I'm a mediator. I'm a certified circuit court mediator. So if a case is in circuit court, the judges can say you need to mediate this case before it goes to trial. In fact, they usually do. I'm one of the mediators that they can choose from to mediate cases. I'm also an arbitrator. Now, arbitration and mediation are slightly different. Florida has non-binding arbitration and binding arbitration. Some courts in Florida will refer cases instead of to mediation to non-binding arbitration. Even though they say non-binding, if you don't accept the result that the mediator has and you wind up getting less, then you wind up paying the attorney's fees for the other side. So arbitration, as you might imagine, is a bit like sword of Damocles or a guillotine. If you decide not to take it, you're going to have to risk paying the other side substantial attorney's fees. Where mediation is all voluntary from the very beginning, and you can walk out at any time, and you don't run a risk of attorney's fees. That's the main difference there. I've also served and continue to serve as special magistrate for Florida Land Use and Environmental Dispute Resolution Act claims. They call them FLUEDRA. There's actually 2 parts of Chapter 70 Florida statutes. There's the Burt-Harris Act that everyone is aware of. If you cause a diminution in value by a regulation after 1995, then you may, depending on the defenses, have to pay for that diminution in value. And that's a cause of action that's filed in circuit court, and there's a 180-day cooling off period before you go to court. And some of those cases are settled, and many of them are, and some of those cases go all the way through a trial where first they decide liability and then they decide the amount of damages. There's also this second part, the FLUEDRA, Land Use Dispute Resolution Act. That's being used by more and more developers and applicants. If they get denied, they frequently have 30 days to file this. That'll postpone any court actions they bring. You may get some of these. You may have some of these already. You may have had them in the past. I've served as the special magistrate who listens to all sides. I've also represented cities as their lawyer in these Dispute Resolution Act claims. I've also represented citizens groups, historic preservation organizations, as interveners to make sure that their interests are heard. In addition to city and county attorney experience, I actually have business experience. I was a business management consultant and analyst, and I worked in the oil sector. And what that entails is going into oil refinery, going into an offshore platform, going into a corporate office in Houston or Dallas or Louisiana, and people look around and say, uh-oh, they brought these guys in to figure out how we're going to do business better. And it didn't always, and hopefully doesn't always include just outsourcing or laying people off. It's actually working on efficiencies. And it was amazing to me because we were able to identify with the people, working with them, what their job really was, what their objective and goal was, and how they could become more efficient at it, how they could make more money and spend less in costs and wind up with $1 million in profits. And that's how we would actually get paid. We would have to demonstrate measurable results over 2 years before we would get paid. So we had to design key performance indicators, we had to set up measurements, we had to look at the reports that everyone was doing and say which things are useless, which things should be done. Unfortunately, a lot of local government, just like business, builds up with forms and reports and regulations. It's almost like plaque on your teeth, and every once in a while you need to go get a teeth cleaning and redo your reports, find out what it is you're doing and why you're doing them. So it's important, I think, to recognize what the overall goals, objectives are, and then reaching them. That brings me to this point, which I'm sure is foremost on your mind. How much money should you be paying for your legal services? Your goal should be to increase efficiency, to decrease costs, just like any business, even though you're a government. The bad thing, parts of it are out of your control. You can be sued by someone, and it's out of your control. But you can help manage those. First of all, whether lawsuits are even filed, and if they are filed, how they're handled and how they're billed. And I think that it's important that you should be working with your attorney, not at cross purposes, but you should all be working together. And you should all be working on an easy, transparent reporting to know if your lawyer is being efficient with the time, if he's answering your questions, if you all have the same goals in mind. Just looking at the past bills, you had a retainer of $5,200 per month. But for the work that was done in June, first for the work that was done in July, you paid an additional $11,410. So you paid $16,610 for 1 month's work. You had 3 or 4 attorneys working on different litigation and different things that's included in that bill. There were 27 hours that were spent in the retainer amount, not 40. There were 27 hours that you paid $5,200 for. That works out to $192 an hour. But then again, you had $11,410 of additional time that was billed at $185 an hour. In June, the month previous, you paid your $5,200, and you had 53 hours of work. So you got more than 40 hours of work. And it's interesting because if you take 53 and 27, you averaged 40 for those 2 months. So you paid $5,200, and that worked out, actually, you had $14,364 in non-retainer work, so it worked out actually higher. You actually paid $19,566 for 1 month of work, almost $20,000. And you had 6 lawyers working on cases for you during that time. From what I can tell, I'm not sure everyone's a lawyer, or some of them may have been paralegals, but I think they're all lawyers. You would recognize the names better than I would. And so what is proposed, I guess, by the first proposer is an $8,000 retainer for 40 hours, approximately 40 hours. That works out to $200 an hour, which is the rate that I charge, $200 an hour. So you would be getting the same $200 an hour for 40 hours at $8,000. But then for anything not on the retainer, they would be charging you $225 an hour instead of the $185 that you're paying now. So I think it's best if you hire the lawyer on an hourly fee. and you pay the lawyer X dollars of money per hour, and that you all work to reducing the amount of time that the lawyer has to spend. My job is to give you cost-effective legal services and minimize the legal services that we have to do. So I think that's entirely feasible. An earlier question was, are you willing to work with us and negotiate? I'm willing to go down to the $185 an hour that your prior attorney was charging. I think we should do $185 per hour for everything, and that you should see the bills for everything. It shouldn't be a surprise to you that you spent $20,000 one month and you spent $16,000 another month. But when you get the bills, you can see, if it's all on one, where your time's being spent. And we can also do, want to get into more detail, a little bar chart about what's being spent on litigation, what's being spent on non-litigation, what's being spent on contracts, what's being spent by each department, and we can see where our needs and our money, and we can see where our money's going, and it helps us manage our money because we know where we're spending it. You know, we know we're spending it on certain things and maybe not on other things, and maybe we can improve the things that we're spending it on so we can reduce the overall amount. So what I would be trying to do is a little bit of business management consulting and analysis with you as we go through this, and maybe 6 months, and maybe 8 months, maybe 12 months down the road, we figure out some milestones we look at, and we can look at where our money's being spent, how we can manage our costs, manage our fees, and reduce the overall amount to the city. I think that would be the best way to go. If you really want this retainer thing, which I don't recommend, but if you really are tied to it and you like it and you like the way that works, I will do $175 an hour for the first 40 hours instead of the $200 an hour. So that would be $7,000 for the 40-hour retainer. That would result in a substantial savings. But I think that may be a little bit short-sighted, and that the other approach that I had without the retainer and just the hourly, I think in the long run we will both identify ways to give you better, more cost-effective legal services and reduce the legal services that you actually need. One of the things that I did want to point out to you, I'm certified in local government law, but I'm also accepted and admitted to practice in circuit courts, in the appellate courts, and in federal courts. So in the Middle District Federal Court, in your local circuit court, in your second DCA. I've done cases in all of them. I have cases pending there in all of them. I do the public hearings, then I go to circuit court, then I go to appellate court, and I go to federal court. I do all that, but the most important thing that I do, and this is what I started doing at Monroe County. When I was land use litigation counsel, I said, hey, you know, I'm tired of getting these cases after you deny something or after you approve something and there's a mistake or there's not enough in the staff report to support it. So what I'm going to do is meet with staff as they're reviewing applications, help them compare the applications to the code requirements, help them draft the staff reports, review what they're writing, discuss it with them, make sure there's backup, make sure there's documentation. If there's something missing, get that information in there because it helps defend the decisions that you make, one way or the other. And you want to make sure that you have enough information that you're making informed decisions and that you're looking at all the relevant factors that might be in your code for either a legislative decision, like a comprehensive plan amendment, or a land development code rewrite, those are both legislative, or a quasi-judicial hearing, like a variance application, or something that's quasi-judicial like a rezoning, but they apply the Snyder standard to, which says you can, has to be consistent with the comp plan, but you can still deny it for a legitimate public purpose. So it's very important if something's coming forward that's controversial or complex, that all the legitimate public purposes are explored and put in the staff reports. Now, I've rewritten land development codes, and I've rewritten comp plans from the ground up, from Bradenton Beach and Yankeetown, and earlier with Monroe County. And we've defended those in administrative hearings with Division of Administrative Hearings, and we won those. We received grants from DEO to help write them. We were challenged in court. They were all upheld. In Monroe County, we wrote a very controversial vacation rental ordinance. It wound up dividing it up by zoning categories. It went to a referendum of the people. It was 49.9 to 50.1% in the votes whether to prohibit or allow them. So we wrote one that works, that's more of a regulatory type ordinance, and that was upheld all the way through the Florida Supreme Court. And it is very important to keep up on the rules because there are preemptions that apply to vacation rentals. There are Burt-Harris Act changes all the time. It's very important to keep up on the case law. There's just been a gazillion Burt-Harris claims filed in the city of Anna Maria that you need to be aware of what's happening with them, how they're settling, how long they're taking to settle, what kind of money is involved. And the other part of being a city attorney that I think needs to be addressed always and isn't talked about is how are you managing your risk? You know, meeting with the finance director and the risk manager to determine, do we have Florida League of Cities coverage? Do we have independent insurer coverage? Are we getting insurance coverage money to help pay these litigation bills? Are all these litigations exempt from insurance, or are some of them eligible? Certain claims, Florida League of Cities won't even cover. Other claims they will cover. They helped the city of Anna Maria settle a Burt-Harris claim for millions of dollars, and they paid out. And so it's very important to spend a little money up front on insurance for risk purposes that cover things like Burt-Harris if you can. And Florida League of Cities, I found, is probably the first place you should go. I'm not saying that there's not private insurance companies out there, but I always start with the Florida League of Cities because I found them as a co-op, if you will, of other cities and municipalities to be really reasonable and to have good litigation counsel. It might come to the point where I don't need to do much of your litigation, or the defense counsel from the insurance company can defend some of these cases and you won't have to pay for it. So that's another aspect. And I don't know if that has been fully explored with you and how long ago you looked at that, but that's something you want to look at. And public records and sunshine law, you need to have a seminar in-house that your staff attends. You need to have it for your boards and advisory boards, not just your commissioners. We need to go through it, and you need to be able to ask questions, and I need to be able to take you through a miniature continuing legal education program. I've got materials from First Amendment Foundation. They write the Government in the Sunshine Manual. You should all have copies of that, and I keep it in the back of my car in the trunk because I'm always getting calls, and the first place I go is that Government in the Sunshine Manual. It's updated every year, and most of the answers to your questions are there, but they're very hard to understand and figure out, and there's a lot of nuances in it. And I've litigated sunshine law cases and won them, and I've for plaintiffs, and I've defended sunshine law cases and defended them successfully for local governments. Same thing for public records. I've sued to obtain public records and won and recovered the attorney's fees. And I've also represented a commissioner who had a public records issue and successfully defended that and settled it settled that case, and there was a spin-off case that was also settled. And what I found with that commissioner's public records case was she didn't get good advice and practical help from the assistant county attorney. He should have sat with her at her computer when she was pulling up Gmails and helped print them out or send them as PDFs or forward them to the county server. No, they just printed them out and then somehow they were lost. The computers crashed, Gmail lost them. Now all these public records that were on a separate Gmail account were lost. It wound up in court for 3 years, and then there was another 3 years afterwards. She had given her hard drive to the county attorney's office. The county attorney's office said they would put it under lock and key, and they actually gave it to the plaintiff, Michael Barfield, who has been doing public records cases all around the state of Florida. And she lost her personal computer PC hard drive to him. And it was given to him by the county attorney who was supposed to be defending the county. So it's very important that you have one-on-one, and that if you do have a public records request and you have any questions, that you're able to sit down with your city attorney and actually look at your computer and do this thing with them. So your lawyer's there to advise you, how to preserve things. As far as my time and availability, I'm available any day of the week. I have some certain days that are hit or miss, set up for administrative hearings, but I can schedule around our hearings. You have a beautiful place, building to work in. I would like to see if we can find a cubicle back there where I can be, as much as I can. I have my laptop, it's a pretty good one, and we can set up a computer there. I can be available to your department heads, to yourselves. We can schedule office visits, or we can talk on the phone. Again, I also have just one phone number. It's a cell phone. It rings to me. I'm the one that answers it. If I can't answer it, it'll go to voicemail. The voicemail also gets converted to text. So then I see that someone's calling and what they're saying, and there's a text message. Even if I'm in a hearing, I can see what it is, and I can go and call you back. And I'm letting you know that now, too, because a voicemail is a public record, especially if it's converted to text. Or if you're texting someone, that's a public record. And if you're texting your city attorney, that's a public record. So you should know that up front before you send any text messages. Those are the kinds of things that I would talk to you about in our seminar. There's the famous story. There was a columnist at Miami Herald that found out one of the commissioners in Miami was texting lobbyists in the middle of a meeting. He asked for the public records, and it showed up, and then he put this personal phone number, cell phone number, up in the Miami Herald. So it's very important that you understand what is and what isn't a public record, so that you don't inadvertently do something that you're embarrassed of later. It may not even be anything consequential, but it can be embarrassing. And we all know that when you're doing public records and sunshine litigation, very frequently there's a political reason behind the case. Sometimes it's not even about asking for a record or politics. It's just a way for attorneys to make money. So that's a bad thing too. You got to be careful of that. Luckily, the legislature this year put a 5-day holding period where a lawyer has to give you 5 days in writing that he's about to sue you for a public record before they can just jump straight into court. Because it used to be if you didn't give it within a prompt response, give the public record, then you could immediately go to court. And so a lot of cases were filed that way. Now at least you know it's coming and you can deal with it ahead of time. I guess I also wanted to say I've been involved in CRAs, CDBG grants, other kinds of government grants, and writing applications, reviewing them, and responding to the CRS program, the community rating system for FEMA. Very, very important for a barrier island city to have your best CRS rating that you possibly can get, because it's going to help the insurance rates of all your residents and all your businesses here. It's also going to help you get money from FEMA later. If you adopt these coastal resiliency policies in your comp plan, and DEO gave us money to write them, and you adopt them, then that helps you with your CRS, and it also helps you with Florida Forever and FCT monies. The program is back on its feet to a certain extent. Governor Scott put some money in the budget next year, so there will be some money for Florida Communities Trust and other things as well. So it's very important that you have an attorney that helps you review your application that's going to FEMA every year and is on top of all the changes that are happening there too. And I enjoy doing that. One of the things, the reason why I stay in law is I enjoy working with staff. And the reason I stay in local government law is I really enjoy working with county staff and city staff. One, I find they're super dedicated. Two, I find they're really knowledgeable, especially in their fields that they work in every day. And then three, they really enjoy having the time to talk to a lawyer about questions that they have and they've been working on. And I get along really well with them, and it's personally pleasurable for me. I enjoy working with those kinds of people. I enjoy that quite a bit. And I've probably covered some of the questions, but probably not all of them. So if there's any more questions or anything else you would like to talk about, please don't hesitate.
Yes, thank you, Mr. Brooks. I appreciate that. In all fairness, I am going to ask you the exact same questions that I asked Ms. Kardash. So my first question is, tell us a bit about yourself and your firm and why you're interested in becoming the city attorney of the city of Madeira Beach. Okay.
Well, I'm Ralph Brooks. As I spoke before, I worked in a lot of cities. I became a lawyer in 1988. Before that, I was at University of Florida Law School, and I was there on an environmental law fellowship. I worked at a place called the Center for Governmental Responsibility. In exchange for working there and doing projects, I received a stipend, a fellowship that helped pay for my books and my tuition and my costs to live in University of Florida. So very early on, and in law school, I was working with government issues. That's where the conservation clinic is. We did reports, and CGR does reports on anchorages. My report was about a chemical called tributylatin, TBT, that they put on the undersides of boats. And it had copper in it, and it was banned in a lot of countries. And at the time it was allowed in Florida. As part of that project, TBT is now banned in recreational boat paints. It's allowed on the big freighters. They travel the world. My second project was on whether or not the Clean Water Act, what they call the irrigation return flow exemption, applied to the Everglades agricultural area, sugarcane and vegetable fields. What happened there was the vegetable growers and sugarcane growers irrigate their crops, and then at the time they were putting that water after the fertilized the plants, there's fertilizer left over, and that nitrogen, phosphorus water was going back into Lake Okeechobee. They were doing what they call back pumping, irrigation return flow back into Lake Okeechobee. So shortly after I did that paper, the U.S. District Attorney Dexter Lightnin picked up on that, and they actually the federal government sued the state of Florida for pollution into Okeechobee and for the pollution that was going to the St. Lucie and the Caloosahatchee. That spun out into major Everglades litigation that was eventually put in front of a magistrate as part of an ongoing program monitoring the health of that. Before that, I was at University of Miami, and that's where I studied marine geology. So I'm a scientist by training as opposed to English or history. Many lawyers are those. But I was a scientist who went to law school. And I grew up in Detroit, Michigan, in the suburbs of Southfield, Michigan. And first came to Florida my freshman year of high school to go to Jack Nelson swim camp in Fort Lauderdale. And then I wound up coming here every year, every summer, and fell in love with Florida. And then once I was at University of Miami in Coral Gables, I enjoyed Florida so much. And I've lived in Key Biscayne. I lived in, first Coral Gables, Gainesville, Key Biscayne, Siesta Key, Key West, Cape Coral, Florida, and now I split my time between Cape Coral and Longboat Key in Manatee County, just across the Sunshine Skyway Bridge. And I want to work here. It's close to Longboat. I love the cities here in Pinellas. I love the interaction, the great issues you have here. I like the CRAs. I like dealing with Pinellas County, believe it or not. You've got some pretty interesting issues and a beautiful place to work and so much potential. And this beautiful city hall and everything else that's going around in this city. I mean, I'm a Michigander who came to Florida for a vacation and never left just because I love it so much.
Mr. Brooks, what do you believe are the most important issues facing the city attorney?
Well, I think it sounds like your question is generic as opposed to this city attorney, but facing the city attorney would be to manage legal service requests, to resolve litigation in a timely and efficient manner, and cases are resolved two ways. They're either decided by a judge or jury, or they're settled. It makes little sense to drag a case on and then settle it at the courthouse steps before you go to trial. As a mediator, I always say mediate early. That's when the benefits can happen. Impediments to that, or sometimes defense counsel doesn't want to settle early because they want to keep billing. So you have to realize also the internal billing practices of outside law firms and manage those outside costs. You have to also realize defense counsel and plaintiff's counsel that are suing you, what is it that they want and when are they going to settle and what do their clients want. It's important to understand, just like there's any bureaucracy in a city government, there's a bureaucracy in these law firms. And so, you have a certain billable amount of time that you have to do every year as a young associate, and it's stressful. It takes a lot of time. Many firms require 1,500, 1,600 hours. You don't have much free time. When I first worked in Miami as an associate with Fine Jacobson, it was a big firm in that semicircular building. It used to be called the SunTrust Tower. I forget what they call it now, but every time you'll see sports on TV and from Miami, they'll show that tower lit up 3 different colors. They, they pull you in and say, listen, you don't do your laundry anymore, you don't wash your car anymore, don't worry about grocery shopping, we're gonna, all that stuff's being done for you, we need you to sit here, we need you to bill these hours. It's stressful, it's hard, I did it for a few years, and then I said, I can't do that anymore. So now I have my own practice, I don't have any secretaries, I don't have any paralegals, I do my own filings. The court system now is e-portal. It can be filed from a PC or from a laptop. You can even file stuff from an iPad or your iPhone. Bricks and mortar is expensive. Bricks and mortar puts people between you and your lawyer. Bricks and mortar leads to higher hourly rates and less ability to negotiate. The partnership structures, the associate structures, all that builds up, all that needs support. It also needs money to keep going. So I'm willing to negotiate with you even as we go forward. If you think we can become more efficient or there's a way to bill less, you're not my only client. I have other clients. I'm one man. I can only work 40 hours a week. I suppose I could work 50 if I really give up my sunsets, but I enjoy them. So my goal is to manage all my clients and be efficient with my time, not to bill any one client the most money that I can get out of that client. I'm trying to make sure that I have enough time to keep everybody happy. Being efficient with everyone that I work with is the way that I do it. My legal services are customized for a particular client, so it's going to be different for each person. Yankeetown, I don't go to all their city council meetings. They don't want me to go there. They don't have enough money to pay for me to go to all their meetings, but many of their meetings, they don't have any legal issues. If they have an agenda, they'll send it to me ahead of time. If I spot anything, I'll talk to them or email or do a memo. I'll go when there's a controversy. There's an election coming up, so I was there last night. If there's certain things that are going on, I'm there. But other times they may not need that. So some cities would perhaps benefit from more customized legal services. And I think with an hourly rate and just doing it that way, it's easier to monitor what's happening. It's easier to see where the time's being spent. Maybe if only 27 hours are spent on routine matters, that opens 13 hours up of litigation money that doesn't have to be in addition to the 5,200. The 5,200 can include a bit of litigation. So and it's easier to track, easier to monitor, and easier for you to gauge and improve on.
Actually, for the record, just because lawsuits have been brought up, I believe, if my information is correct, within 10 days, the lawsuits concerning the developments for Madeira Beach will be dismissed.
Oh, that's wonderful news.
Sort of breaking news, but
That's good.
that doesn't mean we don't have other issues involved here, but, and I believe you've answered this question throughout your speaking, but I'll go ahead anyway. Responsive, thorough legal advice is an important aspect of a good city attorney. Specifically, the availability to communicate and respond to issues via phone, email, and occasionally in person. You will be expected to do this in a timely manner. Tell us how you plan on being responsive and thorough in meeting the legal needs of our community.
I am available by cell phone. I'm available by email. I will be here as much as possible. I would like to have a cubicle if I can get one back there. I notice you have a few. I don't know, they may all be taken. Even if I have to set up over here in a corner or someplace, I'm sure we can find somewhere for me to be at. I do one-on-one meetings with department heads, staff. Typically, what happens is you need a little bit of a filter. So if I don't know what your organizational structure looks like, but say you have a junior planner who has a legal issue, usually they filter it through the senior planner or department director, and the department director will call me and say, hey, we got an issue, or email me a legal request. I don't mind a phone call and getting the answer and getting it back to them pretty quickly. Sometimes I can just give them an oral answer, a verbal. Sometimes people want a memo, or we need a memo, or I need time to research, and then, that's where some of the hours go in also. But the good thing that you get from a city, county, local government lawyer who's been certified since 2004, and that's 13 years now, is that you have 13 years of experience where most questions I've seen before. Some questions I haven't, but most of them I've seen before. So there's less initial research that goes into it. There's still updating, checking the cases, checking the code, checking the statute. But, if someone has a question that I've dealt with before, you can knock out, 5 to 10 hours or sometimes 20 hours of background that I've already been through.
And given the fact that you're working on your own, what do you do if you're ill or incapacitated? What do we do for a deputy
Right.
attorney?
I have attorneys that I can send as a substitute who are willing to do the same exact hourly. And I've had different people step in, all board certified, all who are city attorneys somewhere else. Some who are young, bright, brilliant associates I can call up. And what I do is I hire them as independent contractors to cover for me. If we want, we can have the bill go directly to them, or it can come to me and I can send it to them. So that's how I set that up.
Okay, thank you.
How do you keep your city clients informed on new laws and court decisions, et cetera?
Well, I like to do memos, or I can have a session where I talk. I distribute certain things that come around. I noticed on one of your billings there was something about medical marijuana. In the most recent Florida Bar Journal, there were 2 articles about medical marijuana that had already been written. One by city, county, local government lawyer, Andrew Lannon, who's the city attorney from Palm Bay. So when I see something like that, I immediately scan it and email to the clerk and ask the clerk to distribute to boards and committees and commissions. So you'll get, those articles as they come up, and I'm on the Municipal Attorneys Association, which is part of the Florida League of Cities. I'm a speaker there. I speak frequently on noise ordinances and other issues, regulatory takings, defending takings, and Burt Harris claims. So anything I see on that, I will send around. I don't charge for those. You'll just get an email that comes around with that kind of thing. If there's a particular subject matter that you're interested in, you usually hear about it at a commission meeting, maybe in commissioner reports. Sometimes you might hear about it from the public. Someone might come up and say, I'm interested in opening a medical marijuana dispensary. Do you have any rules in your city? And you're like, oh, we didn't think anyone was going to come. But then when you hear about it, then you might say, well, we need the city attorney to review what the status is of the law on that. So that's something then I would look up and do. But there's quite a lot out there about each legislative session. There's some very good reports that are put out. I'm sure you get some of them through Florida League of Cities. Carlton Fields puts out one that I get. Chamber of Commerce, I go to the Florida Chamber short courses. I'm engaged with the Longboat Chamber of Commerce on legislation. The Florida Bar, I'm in different committees, the Administrative Law Committee, so I hear about all the administrative law changes. I'm in the Environmental and Land Use Law Committee, or Council, and Committee, which I hear and get a newsletter with updates, which I can distribute. And I'm also in City, County, and Local Government Law section, where I'm on committees, and you get a newsletter there that has very good information. And I find the Florida League of Cities is one of the best places to keep up on legislation. There are legislative forums that come up. There are legislative days where people go to Tallahassee. I know quite a bit of the staff that work in Tallahassee for the various governor's office, DEO, the legislature. And I'm sure you, as elected officials, know many of these elected officials even better than I might. And you probably even know many of their staff because they are in fact very busy. So that's something that I endeavor to do to keep you up to date. I also far exceed my continuing legal education every 5 years, but I'm way over always. And I also do continuing mediation education. So I have to keep those up, and I'm constantly learning about new ways to settle cases and to encourage settlement and facilitate.
Thank you.
Thank you. Mr. Brooks, what policies and procedures have you developed or helped develop to guide planning boards and board of commissioners to ensure that, all the ordinances are faithfully followed?
Yep, I think I was talking about it earlier with Monroe County, meeting with staff, helping them look at the code and the applications, making sure the applications meet the code, make sure the staff reports are put together. I've also helped develop quasi-judicial hearing procedures for Bradenton Beach and Yankeetown so that everyone's entitled to a fair presentation, a fair amount of time, and that it doesn't turn into a free-for-all. Sometimes I've been in meetings that have gone all night in other cities where I've been representing people, and that's usually not a good thing. People stop thinking well at a certain point in the evening, be it 11 or maybe 12. There was one Tarpon Springs hearing with the city of Tarpon Springs and a Walmart application on the Anclote that started, I believe, at 5 or 6 in the evening and went till 4 or 5 in the morning. And by that time, it's just a war of attrition, and no one really knows what they're voting for, especially when you have a complex set of conditions and specific conditions that people are talking about. And I've been in other hearings where site plans were literally redrawn during a recess and brought back. And instead of tabling it and bringing it back another day, the hearing goes on, and people never had a chance to review it, and the commissioners don't even know what they're voting on. Trying to set up reasonable procedures for the benefit of the commissioners so that you understand what you're doing is important also. But it's also important just for these city and county meetings. It shouldn't be a war of attrition. No one should have to miss their medication or miss their evening sleep. You can always come back tomorrow or next week and do those kinds of things. But just making sure that everyone's allowed due process, they get proper notice, reviewing the notices of the meeting that comes out frequently. I go to city and county meetings and the notice is incorrect. It wasn't published correctly. It wasn't the right 18-point font that you need for a comp plan amendment. It described the junkyard as something other than a junkyard, or it has something wrong on it. So you've got to be careful, make sure the notice is correct each and every time. You can't just expect it to be there. Make sure that everyone is allowed their time to speak, their presentations all go into the record. People don't forget to leave their thumb drives so you don't lose presentations. Sometimes it's a chore, a task that in legislative versus quasi-judicial. Legislative, frequently speakers in larger cities and counties are limited to a certain amount of time because there's so many speakers. That's easier to do in a legislative matter. In a quasi-judicial matter, if you have an adjoining business or adjoining property owner, they're really entitled to be able to get up and present their experts too. So they're entitled to more time for their planners or their biologists. So you need to make sure you give the applicants and any adversely affected parties withstanding sufficient time to make their presentations and make sure it goes all well. Frequently, the commissioners or chairs will turn to the city attorney and ask for guidance about how to run those aspects of the meeting. So we can meet ahead of time and talk about procedures and then also be there during the meeting if things arise.
My second question, Mr. Brooks, is tell us about a conflict you experienced in which an elected official or an appointed staff member disagreed with some of your legal advice you were providing, and how did you navigate or negotiate that situation, sir?
Okay. Yep, it's a lot better if it happens before a public meeting. So usually, there's, I forget who said this, a famous lawyer, he said, or maybe actually, I think it was in a Michael Connelly fiction book, but he's actually a famous lawyer from Tampa in California who writes these books, Lincoln Lawyer books and these other books. He said, character was the Lincoln lawyers. My grandfather taught me that one thing, and that's the law is malleable. So what I take that to mean, and he was speaking about the criminal law context, which I don't do, But in local government law, if there's an objective or a goal, leave it to the regulatory system and the statutory system to put a number of roadblocks in your way. There's always 10 reasons why you can't do something. But there's always a way to do something, and to do it legally. You just have to navigate around the landmines that are out there and do things correctly. You don't want to do anything that breaks the sunshine law, because whatever you did then is null and void, and you got to start all over again. You want to make sure you dot your I's and cross your T's on public notices. You want to make sure your grant applications are filled out right. You want to make sure your ordinances are written correctly. And if they're not written correctly, guess what? You're the legislative body. You can amend the ordinances at any time. So how many times have you read an ordinance or a section of your code and said, you know, this doesn't really make sense, or this is ambiguous? Instead of just reading by it every time, flag it, you know, put a marker on it, and then, you know, I would say bring it up, and we'll give you some advice, and we might be able to amend it to make it clear. I had one in Yankeetown last night. If the mayor is unable to fill his role, the commission may appoint a commissioner to act as the mayor. So they said, well, that's strange language. And there was lawyers getting up, and they were disagreeing amongst each other and myself. Does that mean act as a mayor, that they are the mayor, or that they're a commissioner and they're an acting mayor? And it made a difference, because if they were filling the role of the mayor, then their seat became vacant and was up for appointment, and people wanted to be appointed to that seat. And so, and it also affects the number of voters, votes you have up on the dais. If there's 5 people, which there was, and the mayor's gone, and one is an acting mayor, and then there's only 4, and then you don't have a tiebreak. So that makes it very difficult. So you want to kind of identify those kind of things. So last night, the one lawyer said, well, act as mayor means they're still there. And I said, no, act as mayor is they fill the mayor's role, and then that commission seats get filled. Unless there's an election coming up in a certain number of days, then they wait for the election. But then we also decided with the commission and myself that we would do a resolution documenting exactly what was happening, that we would put on to the ballot a charter amendment, because we had one going for that section anyway, to change the word "to act as mayor" to the words "to be the mayor." So those are the kind of ways that we got around to that particular legislative issue.
Mr. Brooks, have you ever had to defend a city in a lawsuit? And if so, what was your success rate?
Yes. I'm sure, many, many times, and I would include counties too. Monroe County, I did all their litigation, all their land use litigation. We were successful, I believe, in almost all of the cases against Monroe County. I really can't remember one that we lost during the time that I was there. There was a big one that was lost 2 years after I left, but that I was involved in while I was there. Bradenton Beach, I think we won all our cases. There may have been 1 or 2 that we lost out of maybe 10 or 12. So the success rate in defending cities, I have to tell you, is pretty high. It's much easier to defend a city decision, whether it's to deny or whether it's to approve. You have a lot easier path in circuit court, because the judge will say, I'm not going to second guess the city. You guys are the ones that are elected to decide whether a development goes in or not. I'm not going to second guess this. If there's ambiguity, if it's not clear, or even if it is, and you made a decision, it's very hard to get a judge to overrule a city commission, whether you approved it or whether you denied it. I also do a lot of cases where I represent people that are challenging something that a city did. And it's very difficult to get a court to approve something that a city commission said no to. Usually they don't want to do it. It's a little bit easier, but still super difficult, very, very difficult to get a city's denial overturned and approved. It happens sometimes. And also, to get a city's approval denied, that's very rare. That's almost unheard of. Yeah.
I believe, actually, you've answered in all your responses here pretty much the rest of the questions that we have, as a board have. I think we can probably all agree on that.
The thing on the Commissioner Hodges' question, too, if you're about to lose a case, that's the ones you settle. So sometimes you know This is, when you walk by the filing cabinet, you hear a file barking at you. That was a dog. This one needs to get settled, and let's pull this other lawyer in. Let's come up with something reasonable for everybody and settle that case. So that's another reason I think that sometimes, success rates aren't really a good way to go and measure success.
Can you tell me what your biggest weakness is and what the biggest mistake you may have made and what you've learned from it?
I guess the biggest mistake I made was not spending enough holidays with my parents while they were still alive and thanking them for all they did for me. It's not until you get older in life that you realize, and you have your own kids, and what they did for you. I did get to say thank you a little bit and spend some time with them, but they were in Michigan and I was down here, and I wish I spent more time with them. They did like to come down here, and I did go up there on occasion. It's not like I was abandoned or anything. But I had a very close family growing up in high school, and once I went to college and once I came to Florida, I'd see them only maybe a couple times a year. So that was hard. My sister still lives in Michigan. And that, I guess, involves balancing family with work and with new family. And then mistakes. Well, I think there's some things that people could see as a mistake. If I would have stayed with the big firm in Miami, I'd be much richer than I am right now, much better well off. But I traded that for, peace of mind, well-being, free time, enjoyment, having, full, rich experiences and outside the office. I guess a measure of success is how you measure mistakes, but, I have a different way of looking at things. There was, sometimes things you wish you noticed or saw, or sometimes you'll have intuition, something's not right, and then you don't say anything or don't see it, or it's too late by the time it comes up. And that happens sometimes too. So I guess one mistake is not following my gut sometimes. You can get intuitive intuitions that sometimes have some basis behind them. You don't really know why, but something's not correct here.
Okay. And what motivates you and what made you decide to be an attorney?
Public interest motivates me. If I go to a sporting event, I'm cheering for the underdog. I like justice. I like the law. I like science and the law, the interaction of environment and the law. I'm motivated by Florida issues and Florida places. I constantly am traveling around Florida and enjoy all the different parts from St. Augustine to the Keys to Tallahassee and Gainesville and Sarasota. Each part is so different and so unique and so interesting that it's really quite a vibrant state with some beautiful cities and places to visit. I'm motivated so much by Florida. I rarely leave Florida for travel or vacations. I just like being here so much. I enjoy local government work, like I was saying earlier, working with staff, working with people who are dedicated and dedicated enough to run for office, which is a very difficult thing to do these days, and becoming harder and harder. All the forms and papers and grief that you go through from elections and electioneering and campaigning. It's very difficult. And I've done some Florida Elections Commission defense too, and Commission on Ethics, and worked with commissioners. And it can be stressful being up there, and stressful even when you're not up there, and issues arise. And so I enjoy working with commissioners on those kinds of issues. Electioneering, even the paid political advertisement stuff can get crazy. PACs and lobbying, I've been involved in all those kinds of issues and cases.
Okay. And how would your friends describe you, and how would you describe yourself?
Affable, likable, relaxed, but focused. Able to focus on exactly what the issues and be efficient with the time. Dedicated. I'm always thinking about cases and clients and what they're doing and better ways to do it. People would all say I think outside the box. I come up with innovative solutions. I'm an atypical lawyer, not your normal lawyer. Some people say, you're so nice, how can you even be a lawyer? So sometimes, that's out there. Laid back. I enjoy sunsets. I enjoy beach walking. I enjoy tiki bar with a plate full of local seafood. Music, listening to music, going to your local festivals, seafood festivals, music festivals. I work with a group called FISH in Cortez. It's a Florida Institute for Saltwater Heritage. It's all the commercial fishermen that live in the village of Cortez, across the bridge from Bradenton. And they have a mangrove protection area that they're restoring, and they have commercial shrimping, and they have a heritage museum, and they have classes, and they teach their children about net building and their heritage, and I enjoy that. And I enjoy hiking in the trails of Florida, and kayaking and canoeing in the rivers of Florida, and swimming in the beaches, and bird watching, animal watching, that kind of thing.
You love Florida.
Yes, I do.
And lastly, what are the challenges that you see looking for in this position as our attorney, and why should we hire you?
Well, I think the challenges are to provide you prompt legal advice, first of all. Give you the answers you need when you need them, not late. Be available to you 24/7, Saturday, Sunday on the cell phone if you have a question. Be smart enough and inquisitive enough and curious enough to figure out where you're inefficient and make you efficient. Figure out where you're spending costs that are unnecessary or excessive and reduce those costs. Figure out what it is the city could be eligible for in terms of grants or opportunities with Florida League of Cities, with DEO and Waterfronts Florida programs, with other governmental entities that are around, even with the federal government. What's available for FEMA? What's available for hurricane response? What are these contracts that are going out? How are they managed in real life? What's happening with elevated structures? CRS, all these things. If you're proactive, you can probably bring some money in with grants. You can utilize the grant money you have more efficiently. We have to be careful with taxpayer dollars. It's limited, and we want to do the right thing with them. So we want to make sure, as city attorney, that I'm available to help. You guys set policy, but if you don't know about something, and I know about it, I'm smart enough and curious enough and stimulated enough to let you know, hey, did you know about this program? Did you know about that program? And see if you guys want to get involved in things like that. So those are the kinds of things that I think are out there. And also making sure that your city is fair to everyone that's in the city, that recognize all the competing users, competing interests, that it continues to thrive and be vibrant, that we keep improving, that our quality of life becomes better and better. And it's so hard, because I have a house in the Caloosahatchee River in Cape Coral, and since I moved there in 1998, I've seen the pollution get worse and worse and worse, and the fishing get worse, and the water go from blue to brown. And it's just disheartening. And sometimes it's more than any city could do, but to help, advocate for things like that. The city of Sanibel, city of Fort Myers Beach, they've all kind of banded together in a clean water campaign where they're going to lobby Tallahassee and get more money for Okeechobee and cleanups and reservoirs and things that would help the system. So, those kinds of opportunities are out there too.
All right, well, that's all the questions I have. Does anyone else on the commission have any more questions?
Nancy, you have any? Mr. Brooks, I'd just kind of like to ask you the same question I asked the previous person about home rule, and would you see the positives, the negatives, what's going on with it, and so forth?
Yeah, I'm intimately involved in home rule because of fracking. I challenged for the Conservancy of Southwest Florida the first fracking well in Florida, Dan A. Hughes came into Collier County and they put an oil well in and they fracked it. They fracked it on December 31st, right before New Year's Eve, and the governor shut it down, and they eventually left the state, and they paid hefty fines. But as a response to that, the local governments down there, Bonita Springs, Estero, these are two pretty new cities. Bonita Springs was incorporated first, and then Estero just a few years ago. They wanted to adopt a local anti-fracking ordinance. So you can drill for oil here if you want. You can do conventional techniques, but we're not going to allow you to inject chemicals down into the well. So as part of that, one, I had to research and study the development of home rule from the original Constitution through the 68 Constitution revision to the home rule statutes for both counties and for cities, because Broward County wanted to adopt anti-fracking. And I think I forget how many cities and counties, but after we've been talking about this and holding seminars and meeting with different counties and cities, dozens of cities and counties have adopted anti-fracking ordinances. Each year in the legislative session, the Florida Petroleum Association puts in a bill to preempt local governments from banning fracking or prohibiting fracking. And then there's also been some where they're kind of gray area ones that don't really prohibit it, but they actually do. It's also come up with vacation rentals. It's also come up with agricultural enclaves. The legislature is doing more and more preemption of local government. They'll say in a political speech, local governments know best, let the local governments decide, but then they'll say you can decide everything except this, and that. And so it's growing, and Florida League of Cities is on top of it. Rebecca O'Hare, she was their lobbyist. Greg Kahn went to law school with me at Florida. He's their general counsel. We're constantly battling bills on all kinds of things. And I do believe that local governments are the best to handle certain things and shouldn't be preempted. So I'm very much an advocate for home rule and really fight against preemption. And we're actively have been doing that, for the whole time I've been city attorney. But it's really gotten bad in the past 5 years. So it's something you constantly have to monitor.
Thank you.
The way it's set up right now is a city, because of the Constitution and the statutes, you can do anything you want as long as it's not conflicting with state statute. And then there can be express preemption and implied preemption. Express preemption would be saying something expressly in there about fracking, and then implied is you can't, it would be something in the field of oil drilling. So there's implied and express. And then there was a case, Sarasota versus Browning, about election machines. And they were trying to say that the county supervisors of elections in counties couldn't choose their own election machines. And the Supreme Court said no, it wasn't expressly preempted. There's no implied preemption. If it's not mentioned in the statute, you're not in conflict with the statute, so you can do it. And so it's really scaled back the law on what an implied preemption is. So now the legislature pretty much has to say, you can't do that. They can't just regulate impliedly an entire field. So you have a pretty good law on your side right now. The danger is these individual bills that get filed. And, they're filed by perhaps well-meaning legislators who may or may not understand all the implications of what they're proposing. And sometimes they were proposing legislation on the behalf of particular lobbyists or industry or interest groups. And so, they may be helping them, but then they're preempting you from deciding differently in your own city. And as I mentioned earlier, Florida is so diverse. St. Augustine is so different than Fort Myers or Cape Coral. Every city and every county in Florida has its own ambiance, its own quality of life, its own economic structure, things that are important in Collier County, like oil drilling. They really are insignificant. In Madeira Beach, there's no oil drilling here. So, to say across the board, anything to all cities in Florida, we don't want you regulating anything to do with rehab recovery centers may not make sense across the board. It may not be the same thing in Delray Beach where, they want to do some things about it and they may really know what the problems are in their neighborhood about having unmanaged rehabilitation homes. They may want to set up some regulations. They shouldn't be preempted from doing that at the local level.
Any more questions? No? Any questions from the public? Mr. Preston?
I'll take this microphone if you take that one. Sure. Okay.
Robert Preston, 425 South Bay Shore Drive, Madeira Beach. To follow up on the previous gentleman that came up on the questions on the sunshine with attorneys speaking to two commissioners or two commissioners speaking with a citizen about city business.
Talking to the microphone, I can't hear a word you're saying.
Yeah, they can't be there at the same time. You can't have two commissioners speaking to someone at the same time or amongst themselves about official business unless it's at a publicly noticed meeting. Now, if I'm a city attorney, I can meet with one commissioner on the phone or in their office, and then later, the next day, I can go meet with the next commissioner, but I can't tell that commissioner what the other commissioner told me. That would be called a pass-through, and that's not allowed under the case law. So I have to be very careful, and commissioners have to be very careful not to ask what another commissioner's position is on a particular subject unless they're here at a publicly noticed meeting. And all official business between two commissioners has to be discussed at a publicly noticed meeting. Now, what I also do in my classes is advise people that if they want to have extra meetings or if they want to have subcommittees, there's nothing that prevents you from having an additional committee meeting outside your regular or special or even workshops as long as you notice it and you post it and you allow the public to attend. So Yankeetown is so small that we have trouble getting volunteers for committees. So our commissioners will meet in groups of 2 or 3 offline and between regular meetings to discuss something at the park or, something about, equipment or a grant application, but that meeting will be noticed and posted at the town hall, and it's open to the public, and it's held in a big room where people can sit and watch. It doesn't say in the sunshine that you can't meet, just that it has to be noticed and the public has to be allowed in. So sometimes people think, oh, we can't talk. Well, as long as you give 24 hours notice, you can meet with another commissioner. You just got to put on the notice what it is you're going to talk about, sit in here and take minutes, have someone from staff sit down and take minutes and allow the public in the room. You don't want to bar the door.
Thank you for that. I have another question. I heard you speaking a bit about attorneys asking for records.
Yes.
What about a citizen asking for public records? What applies there?
It's the same thing. Michael Barfield, the man I mentioned, he is not an attorney. He asks for public records routinely. He knows public records law very well. He works with a lawyer. The public is entitled to any public record in a reasonably prompt fashion, and it has to be provided. So it's important that the city set up systems to be able to handle that. Searchable emails, filing systems, computer filing systems. It's important that the computer file folders look kind of like regular file folders. You have to be sorted. They have to be able to be searched by subject matter. And I, make public records requests myself on a daily basis for different clients from all different cities and counties. Yeah.
And a reasonable request time is similar then?
Yeah, and reasonably prompt. And now the legislature did say before you go to court and sue to get the public records, you got to give a 5-day notice. But most public records shouldn't take 5 days to obtain.
Okay. I have one other question, or 2 other questions actually. It seems like you deal with the environment a little bit, and we have a lot of it around us. One, I just want to get a feeling for where you're at, is do you believe that humans have an effect on climate change?
Yes, I'm a climate change believer.
Okay, thank you.
I've spoken publicly at conferences about climate change, and the thing we did for Yankeetown is an adaptation action area and a coastal resiliency plan. And I've also attended the 11 government compact meetings. James Murley is a director, actively works with that group for Miami-Dade, and I attend those frequently. And if you ask Miami Beach, is climate change happening? They'll say they'll bring their engineering department in, and they'll say yes, and we're adequately planning for elevating our stormwater treatment pipes and our sewage system to make sure we're high and dry in 40 years.
Okay, this is something that's kind of near and dear to my heart, and I think a lot of people that live on the intercoastal area, and that is, have you dealt with dirty discharge from boats into our bays and navigable areas at all?
Well, in law school, I talked about that paper I wrote, which was the bottom paint, which was killing organisms, and they got banned as a result. Well, part of my work was on that, but not just me, but everyone else was working, and we got that banned. Certainly, there are marine discharges, and there's marine toilets and all those kind of issues. And I've worked with Bradenton Beach and Yankeetown on the Clean Marina program, and we took the rules that are voluntary for clean marinas and made them mandatory in our land development code. So, and in Monroe County too, you have to have pump outs in Monroe County. You have to have a toilet on your vessel. So there are certain things you can do as a local government that are not preempted. Certain things are preempted if it's navigable waters. So it's a complex field, but there are certain things you can do, especially with marinas and making pump out facilities available and reasonable in cost and accessible.
Just a small follow-up on that, because we have a lot of people that anchor in our bays and are there 24/7 year-round. The boats don't move, the people are living on it.
We had the same problem in Bradenton Beach, and we set up an area. We had to go to the legislature and add to our municipal boundary to take in water, navigable waters, and put them within the municipal boundary. At first, Governor Jeb Bush was opposed to expanding municipal boundaries, and he heard why we wanted to do it, because we wanted to create an anchorage so we could manage these boats that they were tied off to they'd throw engine blocks in the ocean, and then they'd tie rope off to that. And we wanted to go with a mooring buoy and actually manage the field and have pump outs where these boats that were there on these engine blocks also had 5-gallon buckets with toilet seats that were screwed into the top of the 5-gallon bucket, a 5-gallon bucket with a toilet seat, and then that was their toilet, and they dump it over every night. And so our police chief was able to patrol once we got this area within the city. They were able to set up a mooring field. It helped with quite a number of things, reducing derelict vessels, but also reducing certain problems that we were having in the mooring, unmanaged anchorage area as opposed to a managed mooring field.
Thank you very much.
Anyone else from the public wish to speak? All right. Any other business on the council? It's three.
So what's the next step? Is this going on the agenda for the next BOC meeting?
If you
Or-
want it on
yeah,
there.
it's,
We can put it on the
Yeah,
agenda.
if you want it on there. If you're ready for it to go on there.
well, that's next week. I don't know why not.
Okay? Yes, ma'am.
Work.
Works for me. Okay. In that case, we're adjourned at 3:20.